to try to change to the heirs or the estate name to even try to sell it.
Why is that?
Because the stock brokerage firms require, the only way you're going to be able to sell it is now to try to transfer it to a stock brokerage firm. And they have all these requirements of copy of a certificate, certified appointment of the administratrix within a certain period of time of where you're asking them to sell it. Some things have to be signed on the back with bank medallion stamps.
Yes.
It's like jumping through hoops.
That really does sound like it's complicated. And we thought that the will was the easier thing to deal with and straightforward. We didn't touch on it, but the thought that you could avoid probate by having a living trust. Could you explain a little bit about that? Because some people will put assets in that, I thought originally, so they could avoid probate entirely.
Right.
Explain?
So going back to what we said the process is, the idea of changing the name of ownership of an asset through probate court is not necessary if the name of your asset's in the name of the trust. So if you create what's called a living trust, and we want it to be a revocable living trust, the process is you go to an attorney who drafts up what you want to happen with your assets. While I'm alive, I'm the trustee. That's the person who manages the assets. So frankly, there's very little change in your life. Even though you have all your assets in the trust, you're the trustee. Difference might be instead of signing your name on a check, David N. Bazar, you sign David N. Bazar, trustee. But you still manage your life the way you managed it before you put your assets in the trust. The change comes is now when you pass away, you have beneficiaries named in the trust, and you've named the people who would be successor trustees, which would be serving the same type of role as the executor, the person who's now going to be in charge of the assets and distributing the assets in accordance with that trust you created. Since the trust doesn't die when you die, it doesn't have to go through probate. Now, the key to that working is to make sure all of your assets are in the trust. And what we do is when someone creates that trust, we also do a will, but it's called a pour-over will. And what it does is it takes any of the assets that you didn't make it into the trust with while you were alive, and those may have to go through probate, but they just pour them back into the trust.
And the person who you select to take care of that trust after you pass, is that called an executor?
In the trust, it's a trustee.
It's a trustee, not an executor.
It's a successor trustee. And you lay out in the trust what the powers and duties and responsibilities of that trustee are. But they still do have the same fiduciary responsibilities that an executor would have.
Discuss, if you will, and as we hear about it with Michael Jackson, those who might contest a will or contest a trust. Can that happen, and who's likely to do it?
Let's talk about the will first. With a will, oftentimes if somebody, and we want to talk about Michael Jackson in terms of the guardianship issue.
Yes.
Michael Jackson does a will. I haven't seen it, so let's just talk hypothetically. And it names his mother as guardian. Well, the children still have their mother, and their mother as a parent has a right to contest the naming of the guardian. And she's presumed under the law to be the natural guardian of the children as the mom. Now, there may be good reason why she should or shouldn't be the guardian, but she could come in and contest that part of the will, that clause. What we often talk about in will contests is whether the will itself is admissible and whether the will itself was properly executed and the person had the competency. That's what we generally talk about in a will contest.
Making it valid or not.
Right. And that contest has to happen before the will is admitted to probate. So when the notice is given out to the people who would be the heirs who may have been omitted from the will, before the will is admitted to probate, they have to challenge the validity of the will.
And they're likely to do that if they think they won't be getting what they're entitled to, considering they haven't seen the will yet?
Right. That would be the motivation to challenge the will. The reason for challenging the will would have to center on one of several things which would all impact on the person who created the will, the testator, if you will, their ability to freely and voluntarily make the choices they wanted to make in their will.
How do you know that someone is doing what they need to as the executor or the trustee?
Okay. Let's talk about the executor first there. The biggest complaint we get sometimes from people who are beneficiaries of wills is, I haven't gotten my money yet. The estate's been open for a period of time. There's a house that needs to be sold. The executor hasn't sold the house. So it's usually the beneficiaries who are concerned about whether or not it's being administered properly. And what you can do is go into probate court and file a petition and ask for the executor to be removed. And then you have to go in and prove, well, there's assets being wasted, or there's a house that hasn't been sold and should have been sold by this time, although in this economy it's understandable it might not. Or they're holding assets that should be distributed. So those are the types of things in that. Beneficiary of a trust is similar types of reasons that someone might want to challenge how it's being administered, but that would be done through Superior Court rather than probate court.
Do each of those people in their respective roles have to supply a report to anyone who might be a beneficiary? Are they required to give them a report? This is the status of this asset, or I'm not selling this because of that reason, or whatever?
Wills. The executor has to file at some point in time after they've gathered all the assets an inventory of what the personal assets are. So there's a reporting duty right there to the probate court, reporting what the assets are. It's for two reasons. Number one, and this is why people sometimes choose to do trusts rather than wills and go through probate, because that's a public record. And so the assets are reported to the probate court. And the reported, like I said, two reasons. One reason is so they can make sure they've collected the proper filing fee. And also the beneficiaries are able to go in and look and see what are the assets so they can get a feel for what they might be entitled to. So that's the reporting duty. The other reporting duty is on a will and accounting. If the estate is dragging on for a period of time, you have to file an annual report to the court, what's come in, what's gone out, and what's being held. So there's an annual accounting report that's due. Trustees don't have to file those documents. That's one of the reasons people do trusts, so that there isn't any public reporting or public knowledge of what's in the trust or where it's going.
When might someone not want to be the trustee? When would they either not be likely to want to do it, or when might someone not want them to do it?
All right. If someone is older, and they don't have the time or the energy or the facilities or faculties to perform the duties, they may want to resign as trustee, and hopefully the trust will have in it the mechanism for replacing the successor.
A secondary?
Secondary, backup trustee, backup co-successor trustee, something like that, so that some trusts name more than one trustee anyway, and it may say if one can't serve, the other can continue to serve. Or it may say, this is the person who will replace my first choice. In wills, the executor can resign, and if the executor resigns, the court has to appoint a new person to be the estate or personal representative.
Would they necessarily be someone who doesn't have a vested interest in getting something out of that estate? In other words, that they might have some conflict of interest?
Well, generally, I would suggest that the court's going to want to appoint someone who does have a vested interest to make sure that they're managing the estate properly. A conflict of interest might be a little bit different. You might not want to replace an executor with someone who has to be sued by the estate. And let me give you an example of what I'm talking there. If somebody lent money to the person who died, or the person who died lent money to them and they haven't paid it back, well, the executor is responsible for going out and filing suits to collect any assets that are owed to the estate back. You don't want to appoint an executor who would have to sue themselves.
Yes, that makes sense. Now, presumably, if someone has the presence of mind to put together a trust and work on a trust, and say you were working with them, I imagine that you would make sure that the person who's going to be selected as the trustee is asked first. They're not just named without being informed.
Right.
And then also later on, do you end up coaching or taking care of that person who's trustee to make sure that they get to do what seems to be very daunting at times?
Yeah, it's an attorney who drafts the will